There is the bios are in in the material, and I referred to them for the good staid stuff of what bios are supposed to say. I will say that I get this position because I took over like 12 years ago when Greg Bielecki, who had done it for a long time, got appointed to a gubernatorial position, and he bagged off, and I got on, and I've been doing it ever since. But now I've become the president of the Mass Land Trust Coalition. I am a conservation attorney, but mostly I do very little actual practicing law. At one point, I was a real estate development lawyer and a real estate investor. But I also serve on the boards of a small land trust, the Lincoln Land Conservation Trust, and the trustees of reservations. But I now have the privilege of working with Rob Johnson in my role as president of Mass Land Trust Coalition. I just met Chuck Allot a few months ago, but really started again a few weeks ago. Chuck's the executive director of the Aquidneck Land Trust, which is for everybody in Rhode Island knows who they are, and everybody in Massachusetts ought to know who they are as the largest largest land. I think you're the largest land trust in Rhode Island, and the active in the Newport area and on the island, on Aquidneck Island. However, he's also a real estate lawyer who, when I looked through his LinkedIn, it includes that he was a general counsel or counsel for Rhode Island for Chicago Land Title Association, which is the title insurer, which means and I will tell you this about Kathleen as well, these guys know as much about conveyancing and title and all of those detailed stuff that you may have been harboring why you didn't understand your lawyer told you to do it that way. So I strongly urge you that you think about the fact that they're on the piece. I'll let them each say something about themselves as well. But Kathleen is a conveyancing attorney who's done great work with municipalities primarily these days, also on the board of the Mass Land Trust Coalition, and having had worked with not only perhaps the most prominent law firm in Boston, but also with the law firm which represents about 2/3 of the municipalities in
It's only a
Massachusetts.
third. It's only a third.
Only a third of them, and you don't work for them anymore. So, and she's now a consultant doing that kind of work. So it's good. Steve Small, I don't need to introduce. Everybody knows Steve, but Steve is, of course, the nationally recognized as the expert for tax matters, particularly charitable tax matters having to do with land conservation, and there's no more introduction to be done of that. So what we're going to do first, the logistics for today is each of us will give a 5-minute piece on a topic of our choice, not necessarily the prominent topics of the day, but important topics for you to consider. One of the messages of this meeting is that you'll learn things that you didn't know, or that you didn't know you were interested in knowing. And so we try to pick some of those out for us. Unlike the usual method for those of you who have done this session in the past, we're spending actually less time on discrete areas of the law than we are on some policy pieces. And that's in part because it's harder to get feedback. So it's a little bit more of the legal aspects of some policy stuff, as well as some just legal topics about which you ought to be familiar. I think we're going to, now I can't remember who I said we're going to start with. I think we said we're going to start with Kathleen to go on the first of these 5. So once again, if I don't see anything coming into the Q&A, and we only have 2 so far, I will start twisting arms by name, because of course we have the list of all the attendees. So please help yourself get on. Kathleen, take it over, a few things about what you're doing, and then roll into your topic.
Well, actually, so thank you for the introduction. But yes, I am on the board of Mass Land Trust Coalition. I represent a couple of community preservation committees, most significantly the town of Plymouth, which, to the ultimate sadness of poor Stuart Saganor, refuses to join the coalition. I also served on the board of the Community Preservation Coalition and just retired last fall. So my first 5 minutes is talking about an update on the Community Preservation Act. There are now 186 cities and towns that in Massachusetts that have this Community Preservation Act. For those of you in Rhode Island, this is a tax surcharge that's adopted by cities and towns that's supposed to be dedicated to affordable housing, historic preservation, open space, and recreation. There's a state match, which in the beginning was 100%. So 100% of what you raised locally on your taxes was matched by the state, and that was collected through a deeds fee on the registry of deeds. Fortunately, as more and more participants jumped into this program, the match went from 100% down to about 17 or 18. So last year there was an adoption of increasing the fees at the registry of deeds for everything you record at the registry. And so there's now $55 million was distributed to CPA communities in November of 2020. And that will go up as more fees are collected underneath this new registry project. So it's in the sort of the town of Brookline is actually looking at adopting it in May on their election. So as I said, 186, which is half of the cities and towns in Massachusetts. So a requirement for every property that the town or city purchases for open space purposes has to be protected by a perpetual restriction. In Massachusetts, most restrictions expire in 30 years. You have to go through a process with the state to get approval for a perpetual restriction. And so that's what's required under the CPA statute. And then Buzz tells me that the latest numbers from Stuart Saginaw are that probably close to 60% of the land that's been purchased with CPA money is protected now under with a permanent restriction. But that leaves 40% that's still walking around without this requirement met. Department of Revenue is unfortunately the source of some of this problem, because in the beginning they gave an opinion that said, oh, if you own it, city or town, with your conservation commission, you don't need to put a perpetual restriction. It's restricted. And that, of course, was incorrect. And so there are still some cities and some towns, mostly towns, who think, oh, well, I have it with the Concom, so it's protected. But it hasn't met the statute. As Deborah Ellison mentioned in her earlier program on real estate, is that, you can't, some towns gave a restriction to themselves, which is insane, because it's a merger and the restriction disappears. You can't sort of be the benefited and the burden party and have that work out well. So what I think is sometimes the problem is that the process with getting state approval for these was held up by staff changes at DOEA. And now we have John Joya, who's a terrific civil servant who goes through piles of these things. And what we have tried to do, certainly in Plymouth with our partner, the Wildlands Trust, is to combine conservation restrictions. So we will throw in 3 or 4 parcels that have been acquired at various times in one CR, which makes the state's job easier and also the town's job easier. And so that's something that is a time saver and a work saver. The other issue is that, for you folks, is that towns typically forget that when they go to town meeting for a purchase, they just put in the purchase price and they leave out the surveying costs, the appraisal, the legal fees, and the endowment or the monitoring fee that you would be paying to a land trust holder. So hint to you folks is that if you're working with the town on a CR and they haven't acquired the property yet, make sure that they throw in some extra money in there to pay for the monitoring and the costs of the holder. We have found in some of the cities and towns that I've worked with is that it's been hard to find a holder. And especially for recreation, active recreation, which is included in that open space category. And there aren't, land trusts are not organized and probably are not even in their bylaws permitted to have active recreation as a use. And so in that category of the 40% that probably hasn't been protected is probably a good 20 where it's active recreation and the land trust can't be the holder. So as I said, going back to the discussion about working with the city or town as a potential holder is to remind the city or town that, there are expenses that the land trust will incur as an active monitor of this property, and to include that in their appropriation for funding. And I think that uses up my 5 minutes.
Well, that's wonderful. There will be questions. We will have questions after these initial presentations, and then we will go. We'll go to.
You go to the lightning round.
If you hold your questions for the three of us until then, we'll try to do it as a lightning round. That's a good line. I like it. So Chuck, why don't you roll in on your initial topic?
So my topic is a number of pieces of legislation that we are trying to get passed in Rhode Island, and that is done through the efforts of the Rhode Island Land Trust Council, and Rupert Friday takes the lead on all of the conservation legislation that we get passed in Rhode Island. And he's working on a couple bills right now that I think are quite interesting. So the first is a municipal public trust dedication, and this kind of follows along with what Kathleen was talking about in Massachusetts. So in Rhode Island, we do not have a CPA, and so we don't have any statutory mandate about putting conservation easements or conservation restrictions on municipal open space property. And so what has happened historically, if a town wants to conserve open space, is either they put a unilateral restriction on the property, and the problem with that is that later councils then can decide that they want to remove that restriction. And we had a recent case where a municipality actually attempted to do that, and the Attorney General's office stepped in. The other solution is to grant a permanent conservation easement to a private nonprofit land trust. But the problem that the municipalities have with that typically is because the city council people are acting in a fiduciary capacity, they feel that they have to get full fair market value for any interest in real estate that they're conveying. So even though we're attempting to do them a favor essentially as a nonprofit and to put permanent protections on the property, they feel compelled to look for full fair market value. So what we've been attempting to create is a way that municipalities can put permanent restrictions on land that they have acquired for open space or park conservation use. And this tracks a Pennsylvania statutory scheme which follows the public trust doctrine under the state constitution. And our Constitution in Rhode Island actually recognizes public resources, natural resources, land as potentially public trust resources for the betterment of the community. And so the Constitution actually provides the General Assembly with the power to create mechanisms for dedications of land for public trust. And the idea is with that dedication that it would then be permanently protected under constitutional doctrine of public trust doctrine. And so it's entirely voluntary on the municipality's part, but through a resolution, they can actually make a dedication of these open space lands under the public trust doctrine. And so that is what we're attempting to get through. It's worked well in Pennsylvania, and we hope we can get passage in Rhode Island on that. The other statute we're looking at is a liberal construction clause in our conservation restriction statute, which is Title 34, Chapter 39 of the Rhode Island General Laws, is the enabling act that allows for conservation restrictions and allows for their permanent enforceability. The problem is that that statute is essentially in derogation of common law, because common law has a it favors the free alienation of real estate. Any statutes that restrict the free alienation of real estate are they're viewed to be contrary to common law, and therefore there are common law defenses to challenge those. So what the liberal construction clause essentially does is it puts the presumption back in favor of the conservation, and if there is any ambiguity in a court case dealing with a conservation restriction, the presumption will be in favor of the enforcement of the restriction, as opposed to the common law version, which would have been a presumption in favor of the free alienability of real estate. So what it really is, it's an understanding that conservation restrictions are for the betterment of the community, and therefore the common law doctrine should be essentially viewed, the presumption should be against that common law view. So, and you see these liberal construction clauses in most conservation easements, in many contracts, and in other enabling statutes. So we're just attempting to put it into the enabling legislation for conservation restrictions as well. That's it.
Perfect. Thanks. I will take the opportunity to say these are things that I know you're working on in Rhode Island. Have bills been? Can you let us know? Have bills been submitted? I know you don't have a full-time legislature. Is Rupert pushing these, and can they look to Rupert as to what any of the Rhode Island part of our audience do to help at this point? I presume it's a little too early to have everybody call their legislators, but will Rupert put everybody, he tell people?
It is not too early. They're actually holding hearings on both of these bills. So it would be appropriate to contact your legislator and let them know that you are in favor of these two bills. And if you have questions, yes, the contact person would be Rupert Friday at the Rhode Island Land Trust Council.
And as I always tell people who are calling their reps on behalf of an organization, if you get good information from them, let the organization know. So particularly if you happen to know the rep well, make sure Rupert knows about it and knows you had the conversation, knows what the issues are.
Exactly.
Kathleen.
So I had a question, because in Massachusetts we have Article 97, and there's a process to get out of it, where you can go to the legislature and get special legislation and request that you could take the property out of that protected status. Is there some out for these things?
That's a good question. I mean, I don't think it's built in that way, because I think that's been the problem, is that one council tries to put the protection on these properties. Yeah. And then a later council comes forward and decides, no, we want to build a police station on this property. Right. And therefore, we're going to take the restriction off. So we're trying to create something that would have some permanence under the constitutional provisions of the state. Mm-hmm.
Okay. So we'll rotate. Maybe you can rotate back on this when Steve's done. But I would wonder whether a council could invoke a charitable trust onto it, which couldn't then be revoked without having the Attorney General run through a cypre kind of analysis. So the Attorney General might be able to step in. But we'll get to that, because I want to touch on amendments a little bit later too, and I know they play a role. Steve, take a shot.
Thanks, Buzz and Chuck and Kathleen and all. Let me be clear about what my perspective is. I think almost everybody who is watching is in the land trust community, government community, conservation organizations, and so forth, although not all of you. I'm not a flora and fauna lawyer. I'm a tax lawyer. And you're all perspective, certainly the land trust perspective, restriction holders and donors, grantors. They want to protect the resource. You want to protect the resource. That's your job. That's my client's job. 90% of my clients are private landowners, and that's their goal. I have a different goal, which used to be easier to meet than it is now, and that is I want to keep my clients out of trouble with the IRS. And in the old days, that was pretty easy because it was the IRS wasn't paying much attention to this field. And without any case citations, which I'm intentionally leaving out, over the past couple of years, a number of well-accepted, good faith, mainstream drafting template provisions that we thought were fine, the courts have said, no, that doesn't work. And so the field is very much in flux. There are some fundamental drafting issues. And again, I'm not talking about protecting the resource, although we might get to that in a minute. Fundamental drafting positions, the key words for which are not abundantly clear at this point, in part because a lot of these cases are on appeal. And I would just digress and say one of the problems, counterintuitive, we've wanted the IRS to go after these big syndicated conservation easement deals, and now they are. But as I mentioned in the program yesterday, the syndicators and promoters have multi-millions of dollars to spend on lawyers and public relations. And so they are challenging all of the negative court decisions. So the process is just going to take a long, long time. One of the things I do want to mention today, and as Buzz has said, and as we all have said, this is a short program to cover a lot of material. So obviously we have to cut a lot out and give short answers. For those of you who are interested, there are two opportunities to have longer sessions. One, of course, is the Land Trust Alliance Rally, but that's not until October. I would also mention that we have a program, Trying Times, that was a webinar last year. Nancy McLaughlin, Karen Groves, me, and some land trust people, and Mark Weston, the appraiser. That's going to be offered in May. The website is just now up. That's 4 hours. You think there's a happy medium somewhere between 45 minutes and 4 hours. But if you Google University of Utah Law School Trying Times, you'll find the information for that. Highly recommend it. Part of the importance of that is the calls that we have getting ready ahead of time, where the IRS representative may feel free to speak a little bit more freely. So everything's in flux, and I think the trickiest issues is amendment provisions in conservation restrictions, conservation easements. And we'll talk about that a little bit later. But again, I know we're going to cover that more at Trying Times. I did want to pick up on two things that Chuck said. One is just one of my decades-old sayings: never trust an unrestricted piece of land. And I guess he's talked about situations where sometimes you can't even trust a restricted piece of land. So certainly, if the land is unrestricted, if it's town land, if it's owned by the girls' school, if it's whatever it might be, and we take it for granted that it's open space, that doesn't necessarily mean it's going to stay that way. The other one, much more significant in the longer term, I think. Chuck pointed out that one of the reasons they're pushing conservation is for the betterment of the community. And I think that's a very important concept, but I want to narrow it right down here. How many times have we seen owners of property, either irrevocable trusts or corporations or whatever it might be, where the people who control that may have been, an entity may be willing to convey conservation easements, but there's a fiduciary responsibility not to lower the value of that asset. And they can't. And I think that's the law in every state. And I would love to see law develop over the next however many years that protecting land for conservation purposes is consistent with fiduciary responsibility. That's all for now.
That's actually very interesting. I would just note, Steve, that that Steve's talking about the trying times. He did mention one person who happens to be head of the conservation discussion charitable division for the IRS. So the point is, this is a place that is mostly it's the legal wonks who go to that, but it really is a very high level discussion of where the IRS is going and what kind of transactions can you be comfortable with and shouldn't you be comfortable with. Steve.
Last year we had 450 registrants for that, and 100 of them were from the IRS.
Wow.
Which shows how much Karen is respected in the community at large.
No, I think they're trying to figure out what else they can attack that we're doing, actually.
Right.
So you're probably educating most of them.
Oh, yeah. The problem is, Steve would say, first of all, I should say that Steve had a session yesterday, and all of these sessions are recorded. And for those of you who really deal with any sort of a charitable contributions of either fee or CR or CE, conservation restrictions or conservation easements, ought to listen to that, ought to go back and listen to that session. Similarly, Deb Eliason did a session on conveyancing, basically the due diligence you need to do, that Kathleen referred to, and that's another one that, so we'll try not to deal with those issues to the extent that we can, but you really ought to go back and listen to those as well. Fortunately, there are some comments that have been kicking in already at the Q&As. I would say keep them coming, but I'll refer to the first one because John Joya, who, as everybody in Massachusetts knows, but nobody in Rhode Island knows, John is the Division of Conservation Services person at the Executive Office of Energy and Environmental Affairs, who looks at all of the CRs under the program that Kathleen mentioned of state approval of CRs. And John mentions that with this, referring to the municipality issue, that municipalities can't get funding that assists CPA purchases if there's a CPA purchase. They also use the state grant money out of EEA that they have to have the CR in place. So that's a good incentive for municipalities to do it. And then he also mentioned something that I'm curious about whether particularly Chuck and Kathleen think it's a good idea. John endorses what he called the super CR, which says, geez, if a municipality has acquired a bunch of properties and now they're going to put them under a conservation restriction, that there can be a super CR that just links multiple properties. Clearly, that's a good idea if you're trying to help a community that has had a bunch of properties acquired by CPA and now they're going to roll them into one. So let me extend that a little bit to what you, Chuck and Kathleen, feel about having maybe a landowner that has several properties or some other institution which has separate non-contiguous properties, putting them under a super CR. Chuck first.
I mean, my concern with that would always be that you're making proper recitation to the conservation values of each of the properties. And I just think, if you're combining a lot of properties together, it's hard to give enough weight to the conservation values of each of those properties. That would be my concern. I don't think it's a problem from a conveyancing standpoint.
Yeah, I think, I mean, we are doing super CRs in Plymouth with John's assistance, because we have a holder, and we sort of try to lump similar properties kind of together. I think going to Chuck's point, there's usually a description of, what are the uses and that sort of thing. So you have marshland and maybe you're allowing, mowing and you're going to allow cranberry harvesting or whatever. I mean, so you really have to put the like things together. So the sort of a blanket, everything we own in town is in the CR, whatever, I don't think works from a perspective of describing what the benefits are. And then going forward, Buzz, as you know, I mean, there's always a situation of trying to make sure that who the benefited, with any restriction, who the benefited parties are and what are the changed circumstances that might allow for, some change to the restriction. And if it's too general, I don't know that you'd be able to, protect what you need to protect. In the future, somebody says, oh, well, this is, we have changed circumstances. We're all underwater. We don't need this open space anymore or whatever. And that because you had such a general CR, you wouldn't have outlined what you were trying to protect. That would be my concern.
Interesting. Steve?
Very quick comment, and I hope nobody's thinking about this, but I just wanted to clarify that when you all are talking about super CRs and bundling, that would not work if it's 5 or 6 or 7 neighbors or 2 or 3 or 4 neighbors privately owned real estate in the same community, whether they're abutting or related or whatever it might be. There are just too many problems with combining more than one ownership and more than one piece of property in one conservation restriction document. And that's for the 4-hour program, so I'll just stop there and say don't.
I know of almost no topic on which Steve would comment that it wouldn't be a 4-hour discussion, but that's okay. Let me raise harsh. One place that might be of interest for people, particularly those who do cluster subdivisions or open space residential developments, as they're now called in Massachusetts. The little town in which I work has had many of those kind of subdivisions where the land is either put into conservation to either the municipality or the land trust to start with, or a CR is granted to the town or the land trust, and the land is held by a homeowners association. I presume, Steve, the comment on the super CR, I presume having multiple landowners who are within a homeowners association, if they were taking the open space around a cluster subdivision and which had a CR and deciding to give it to the town or the land trust, one would look to the homeowners association to see how authority would be delegated and whether it took a unanimous vote or a 2/3 vote or something. But you would have no qualms about a group of homeowners who jointly owned a piece of land around their subdivision granting a conservation restriction or fee, correct?
Correct on those particular facts. And the key, which you didn't mention, but the key from my perspective is there's no income tax deduction being claimed. And so if there's no income tax deduction being claimed, a lot of the rules that I worry about just don't apply. And one of the reasons I'm opposed, for example, of 3 or 4 or 5 neighbors getting together and conveying a conservation restriction is how does the appraiser divide up the deduction among the different land? You're just looking for trouble. But in a homeowners association, that's fine. Similarly, with an LLC, it does make it a little bit simpler if it's one title holding entity. But if they're different parcels of land, I think you run into the same problem. In other words, who gets how much of a deduction? No deduction, piece of cake.
So let me do 2 things first. Chuck, in the Q&A, somebody's asked if you have the Rhode Island bill numbers, and if you have, can you post them? And if you can't, can we get Rupert to to post them somewhere?
So the 2 bills are in the session. I don't know where they are, but I did have them filed. I do not know what the bill number is on the municipal public trust dedication, but I will find. Well, actually, I think the best thing for people to do would be to contact Rupert on that to get that bill number. The other one, it is in there. It is Senate 94 is the one on the liberal construction provision. is Senate Bill 94, 2021 S94.
Great. Well, that's helpful. One of these, since we were talking about municipalities and some of those issues, there's a question about how if there's a municipal. I had this in my session yesterday about enforcing. I posed the question of if a municipality is the landowner and a local land trust holds a conservation easement on the town land. How do you deal with enforcement, because the political issues and the PR issues are so great? I would pose that up here in the context of saying, should they take them at all? And if so, would you suggest, I know that in Massachusetts, John Gioia would be receptive to different language where the municipality is a landowner, but are there particular thoughts, particular provisions that you would think automatically you ought to think about whether you change it? And the one that comes to mind for me, for Kathleen's purposes, is the disgorgement of the getting a percentage of the interest if there's a taking of the land. But thoughts about municipal landowners and land trust CR holders? Steve.
Well, one of the things that has come up lately is that if there's a situation where a property owner is complaining about, the use of the property that's dedicated to trails and stuff, and they're, if you're claiming damages and things like that, you got to go to the right court. So most people think, oh, I would head off to land court, but the land court doesn't have jurisdiction over lots of that stuff. So you're off to superior court, and you have to go through a whole process for notice on suing a town. I mean, there's a whole, the tort statutes and all kinds of things that protect cities and towns that don't protect individuals. So you have to keep that in mind. If you're the holder of the CR seeking an enforcement and damages and things like that, you're off in superior court, not land court.
Oh, interesting point. Yes, Steve.
I'm involved in a matter right now in a locale that shall remain anonymous, land that's owned by a charitable organization, good group, under CR to the local land trust. And both of these gifts were made a long time ago by the same grantor who owned the fee. And there are arguments in town that the charitable organization is very much overusing the property, going way beyond the intent of the grantor. And you want to talk about political, what is a land trust to do in a situation like that? And I've been kicking this question around with others. And one of the things I learned, by the way, the Boston lawyer should stay out of town hall. So I'm staying as far away from that as I possibly can. But whether the Attorney General's office has a role in somehow, we don't want to fight here, but we want the expansion to stop and maybe shrink back down a little bit of the usage. It's supposed to be tranquil and serene, and it ain't anymore. So very difficult issue. I mean, these are hypothetical. 30 years ago, this would have been a hypothetical, and now it's a real fact pattern. The other thing I wanted to mention, Buzz, you said, talking about the homeowners association and making sure that they had the authority to act and sign the deed and so forth. I think that's another issue that doesn't get enough attention by people drafting and accepting conservation easements is, first of all, who's the grantor? Okay, if it's Sally, that's easy. If it's the Sally Smith Family LLC, does the LLC have the authority to sign that conservation easement? And there are a lot of questions that follow that. That's a 4-hour program, but there's a lot of due diligence that needs to be done on stuff like that that isn't being done. And I do know of one case where there was, getting back to my earlier comment, there was a bargain sale of a conservation easement on a very important property out west. One owner was a son, another owner was a son, the third owner was a trust for the benefit of the sons and grandchildren and so forth. And it was a bargain sale, and people who think about this aren't telling anybody anymore. but it's quite doubtful whether the irrevocable trust had the authority to sign that conservation easement and engage in a bargain sale and give away that value. And if that's correct, if anyone ever challenged that, that would make the easement invalid. So think about things like that. It's a can of worms from there.
Yeah, well, Deb mentioned that in her program about the fact that, you need to check on the due authorization. Going back to what Buzz was saying about the cluster zoning and open space residential, there's been a real problem with cluster zoning in that you could just say, oh, it's with the homeowners trust. Homeowners association is going to hold it as open space. And the problem is that a lot of those go out of business. I mean, the first, Chuck, that they're around for a couple of years and then, nobody's paying any attention. And so nobody's monitoring it. So the new housing choice bill, which was signed by Governor Baker in January, is kind of beefing up that cluster zoning to open space residential, which has an actual requirement that you have to transfer the open space to the municipality or to a land trust, a nonprofit. So, because this idea of these homeowners associations, I mean, you and I both looked at them, all the time when we're doing titles and stuff like that, but most of the time there's nobody around.
Right.
So I would reiterate two messages that come out of that for the practitioners. One is for both Steve's comment and Kathleen's. It's a good reason to get title insurance because the title insurance guys worry about authority, and so it's well worth. Most people think some land trusts always get title insurance. The land trusts with whom I work tend to get them only if there's a kind of issue, because they can be somewhat expensive or tedious to get. But that's one of the ways to cover the authority issue. Another, of course, is to get an opinion of counsel, and that can be the conveyancers, the grantor's counsel who you might rely on in that circumstance. Let me keep moving by taking on the homeowners association one more time, because Anna has raised the question of whether does the town have a responsibility if the homeowners association simply dissolves or goes out of business. In my experience, and I've had several because my town has so many cluster subdivisions, they don't go out of business, they just fade away. It isn't like they stop holding meetings or they dissolve themselves. They stop holding meetings, they don't dissolve themselves in any formal sense. And municipalities have no obligation, I think, in that circumstance. The good news is at least one could argue, and maybe the holder of the restriction would argue, that the zoning is no longer approved because the zoning required the open space to be held by either the municipality or the land trust or a homeowners association. So I do agree the new bill is really helpful, but I have not ever seen a case in which the homeowners association just decided, oh, to hell with it, let's just give the land to the land trust or the municipality. So it's an interesting qualm.
But someday we will. That's another one of those hypotheticals that will mature into a fact pattern.
So Steve and I are old enough, I won't say anything about Kathleen and Chuck, but Steve and I are old enough to really know about how all those hypotheticals that we used to talk about 20 years ago, they just happen. And maybe they happen because of second or third owners who had none of the charitable desires of the original. And maybe it has to do with the fact that there are more regulatory restrictions now or easements now than there used to be. And maybe it has to do with just the fact that people are becoming more concerned or more willing to litigate, but they are coming more and more frequently. It's always a problem. Steve.
A combination of issues. And as I've said often in the beginning, those of us who were involved decades ago thought we knew the answers to all the questions. And it turns out that was only because we didn't know all the questions. And as we figured out the questions, we started to answer them. And now the courts have said, no, some of your answers are wrong. So particularly difficult time to understand what the right path is here. Do the right thing. I think one of the messages that I would leave this program with is you got to do the work. It's harder than it was before, although the program's not over.
And it is a reason, it is a reason I would say why you really do need to look to counsel more frequently than you might have before. On the other hand, I would say on behalf of the all volunteer land trusts that, that trustees can be really, really capable and good people who know what they're talking about, maybe more than some, what I'm old enough to call them wet behind the ears, staffer, who's got a grant, who's got a degree in land conservation. But you really do need to know when you need to seek more information. I will note real quickly that Rupert has put into the chat the bills that Chuck was talking about. So anybody who wants those bills can hop over there. And then I had a great question because it was on my list to ask. Kelly was interested in whether the question is in the tune, and this I think again is for Chuck or Kathleen, but an easement held by the land trust, can it be lost if it's not used for a certain period of time? Let me expand that a little bit and ask you to comment on both prescriptive easements and adverse possession, as they can be used. Can they be used by a land trust? And can they be used against the land trust? And I think I know the answer in Massachusetts, so I want Chuck to go first.
So we've done a good job in Rhode Island with respect to the protection of conservation restrictions under the state statute. So conservation restrictions are not subject to any of the curative legislation that would extinguish ancient restrictions. It's also not subject to adverse possession. So as long as the adverse possession that right wasn't created prior to the statute that basically excludes it from any kind of adverse possession claim. And you always have to make sure that in Rhode Island, it's 10 years, that the period of adverse possession isn't before your statute was enacted. But if it is not, then our conservation easements are protected from adverse possession, marketable record title, pretty much any of the statutory schemes that would affect the perpetual nature of a conservation easement are covered as far as I know. I don't know of anything that affects its perpetual nature in Rhode Island.
Great. So before Kathleen speaks, let me correct. The question is also if the land trust has an access easement, not a conservation easement, but an access easement of some sort, a more traditional kind of easement over a Serbian property, can that be cut off by adverse possession?
Absolutely.
Okay, Kathleen, I don't know that that's true in Massachusetts. Kathleen, what are your answers to all of those?
Well, because a couple of things here. First of all, you can't get adverse possession in Massachusetts, and I don't think anywhere else, against the federal government, the Commonwealth, or any of its subdivisions. And so you can't. If you're walking you have a trail that's on the town land, you can use it for 1,000 years, but you are not getting adverse possession against the municipality.
Correct.
So the question comes up sometimes about abandoning. Have I abandoned my easement? You can't abandon a restriction. That's a completely separate thing. An access easement, potentially you could abandon, but the case law in Massachusetts is really tough on trying to show abandonment. Not using it is not abandonment. Building a building on top of it, or putting a hazardous waste site, whatever on it, that might be abandonment. But that's, not using it is not abandonment. And there's a bunch of cases on that already. Adverse, easements by prescription. Adverse possession is actually taking the fee ownership, but you can also get an easement by prescription. Where you use it in Massachusetts, it's longer than Rhode Island, which would be 10 years, but us it's 20. But you use it for, easement by prescription. The important thing to remember is that you only, in an easement by prescription, get the way you've used it. So if there's an access trail that, you have in the wrong place and people have been walking on it, That's all that easement is for, is people walking. You can't take an easement by prescription that you've acquired over the 20-year period and then say, I'm putting in a 4-lane highway and, 16 houses. So the easement, the prescriptive right you get is the right you exercised for the relevant period of time.
Right. Steve.
This isn't exactly the same, but it brings to mind one of these tricky issues. I was working with a community in Massachusetts that wanted to acquire some land that it did not own. And one of the questions we looked at is whether there has been a condemnation of a conservation restriction. Instead of condemning the fee, just condemn a CR. And we know that there were consensual condemnations around the Quabbin. There's a lot of that material. But I do not think, just for your all information, we were able to find any evidence except maybe some 1946 Michigan case where there was actually a condemnation of a conservation easement. And obviously at that point, it wouldn't have been a contemporary conservation easement. It's something to think about when it comes to land acquisition.
Steve, weren't they doing condemnations of conservation easements for the utility line that was going through the state of Maine? I forget what it was called, but I thought that they were actually seeking out conservation easement lands because they were less expensive to condemn. And I'm just surprised that there weren't any as a part of that whole utility line that was coming down to Massachusetts, I believe.
There's a lot of information back into that question, but one position I think that a lot of us hold is that if land is subject to a conservation easement and it is condemned, the condemning agency still must pay full fair market value, and the proceeds of that get divided between the holder of the easement and the holder of the fee. And so I understand some municipalities have thought, well, we can condemn encumbered land and it won't cost us as much, but I don't think that's right. And I think obviously if it came to that, there'd be some law on it, but I'm not familiar with any law on that right now.
Yeah, I think there's some, I think I've picked up out of the Land Trust Alliance Conservation Defense Committee that there have been some of those. I'm the most close to many of us in Massachusetts was the gas line that is not being built now, that was coming from Pittsfield over across the northern third of Massachusetts, and it was cited to cut across mostly state forest land. I mean, it was really cited to be on public property because they knew they could get it less expensively. And the land trust community did rise up and make it clear that anything coming across land on which they held conservation restrictions would have to be at full fair market value, as one piece they said. And then but so I don't know so much that they could. I think nationally anyway, it's relatively clear that if you condemn an easement across land that is subject to a conservation easement, that it is a termination of that easement, and the market value, the fair market value unencumbered, has to be taken into account, and then the funds distributed in that way. Other points. So there's a question here. I like the questions. They're sort of going into things I'm personally interested in, so I'm taking those first. We will try to get to abandoned ways in a minute, but there's a question that's back on the easements, rights of way easements, not conservation easements. What is the right for, if land trust holds an easement that includes a trail easement, a granted easement? Does that include anybody? Unless, assuming the document to granting it, the conservation restriction or easement that provides for the easement to cross private property, does not preclude some nature like everybody or really limited, can they invite the whole public? Can the public be invited? And I think the answer to that's yes.
Well, that's an interesting question, Buzz, because we have that coming up right now, where the it's language that's in the grants, and so I've looked at a bunch of trail easements over the years, and the older ones will say, oh, as part of this cluster, we're going to give an easement to this trust, and it's for anyone any resident of the town. And so I don't know whether you're supposed to be standing out there checking people's driver's licenses, but it's kind of nutty. And then the later ones all say, any member of the public. So it seems like in the early days of cluster zoning, the way you got, a developer to agree to it and to the property owners to agree to it was to say, oh, well, it's only those of us wonderful people who live in this town and not the great unwashed from somewhere else. I don't see how that's even enforceable these days.
Yeah, so I would say that I don't know whether Kelly lives in Lincoln or not, but Kathleen's laughing because she and I are working on something that has precisely that issue that has actually gone to litigation. So it's intriguing. I think we have confidence that in that case we will win. Steve, you got a thought?
I'm working on something that has a similar issue, a very important piece of property. Owners want to put a CR on it. The land trust that intends to accept the CR wants public access written into the CR. And I've run up against this many times before, and I've had landowners who have said, well, public access is fine with me as long as it's the bird watchers and the pedestrians and so forth. But if it's the boom boxes and the six packs, how are you going to help me maintain the tranquility and the serenity of my property if we write public access into this easement? And in this particular case, we've come up with a 6 or 7 page access management guidelines on the responsibilities of each party. Listen, I know I should have prefaced this by saying I don't want to come up with the works, but access management guidelines, one of which allows the landowner to pull a plug on access if it does get out of hand for a period of time. And I just give everybody a heads up, this deal probably will close at some point this year, and there'll be something in the record that if a landowner doesn't ask the question, don't worry about it. But if a landowner says, what are you going to do? I think they are owed a fair answer.
Chuck,
I think
Right. And land trust will run in the other direction if they have an affirmative obligation to defend or to police their own peace. Chuck, I'm sorry.
So I think it's a great drafting consideration. Anytime you're putting public access into a conservation easement, that at a minimum you want to put a restriction in there that the land trust can put in restrictions as to time, manner, and use, so that it's clear that it's public access, but that doesn't mean unrestricted access.
Absolutely.
And that, right.
So let me roll into to how that works out in real life. It says the trail easement. The easement says access by foot between the hours of between dawn and dusk, and that's all you have the right to do. So bicycles start running over it. Bicycles with headlights in the middle of the night. Is it the land trust's obligation to stop that from happening at no matter what the expense? Or is it rather that the landowner can go out and hijack them or call in the police for them or whatever that's worth? Let me tell you, but before Steve answers, that what I've done in that situation, or almost any situation in which we hold an easement or the land trust holds the easement, but there's a problem like that, is all we've agreed to do is to say, well, we will agree that, I always start with, we'll agree that you can put up a sign that we approve. You can use signage. You can make requests, but the land trust does not want to be obligated to have to go out there and send people out at dusk to make sure there's nobody working on it. Steve.
That question, the short answer to that question is who's responsible, being the question, is that's exactly why when this has come up in my work with landowners, I've said on behalf of the landowner to the land trust, okay, we're willing to do that. But how are you going to help us out if things get out of hand? And that's where these plans evolve. And they're common sense plans, hours of use and pedestrian use only and things like that. The first time this ever happened was on a major property in New Hampshire after working with the land trust for about a year. And we finally came up with an access management guidelines, and the land trust came back to us and said, you know what, we don't have the resources to hold up our end of this deal. So we'll withdraw our request for public access, and you just continue to let people use the Monadnock Sunapee Trail like you have in the past years. And the family said, fine. So it could be a tricky issue or not.
Yeah, it does show out well. Chuck.
Well, and I just think you might think that it's kind of very unique circumstances that this would ever become an issue. But dogs on leashes is a huge problem on trails.
Yeah.
And, you know, and how, you know, if over and over again people are getting, attacked or dogs are jumping up on them, I mean, what are we supposed to do as a land trust? It's really a difficult situation. And then, you know, what's the remedy? I mean, does it pose a situation where we're in violation of our own easement if we're not properly enforcing those provisions?
Well, I would argue on behalf. I'd argue on behalf of every land trust I know that the land trust would say, well, it's not. We will work with you for a resolution of it, but these people are not operating under our easement. Therefore, they are trespassers to you, Mr. Landowner. And you can do what you want with them, but we're not liable for it. Having said that we will do what we need to do. And if that means closing the trail, you close the trail. And in a small town with a small land trust, that can cut both ways. But I would suggest that a single town land trust that puts up a sign that says, because these trails are not being used appropriately, we're going to have to close this trail, and we're going to do it for 90 days now. And then we'll reopen. And if the motorbikes keep coming over it, or the snowmobiles, we had snowmobiles once, snowmobiles keep coming over it, we will close the trail permanently. But we're not going to be liable to the landowner. We're not going to allow ourselves to be liable to the landowner for that. Kathleen, I sort of cut you off. Go.
I think it's also an issue if it's an open carry state.
Sorry.
Kathleen first.
Oh, I was just saying that's a huge issue, especially now because of the COVID regulations. I mean, COVID pandemic, right. Everybody's out on these trails, and they're out in the trails all the time. And so, I mean, I have a park across the street. It's a town park, but you know, people are apparently calling the cops every night because there are teenagers walking through it. So, you know, I these days, I think it's hard to get a town to, you know, respond with their police department to answer some kind of issue. And, you know, and the idea that you're going to have volunteers in a land trust stand out there and sort of, you know, read the riot act to people, that's not happening.
Right.
Go ahead, Steve.
Exactly. Steve.
Two things. And number one is, I think, you know, whose responsibility it is and whether things get out of hand. That may depend in part on whether it's an open carry state or not. But the other thing is putting in a number of our conservation restrictions now, and this is not news, but for those of you who haven't thought about it, grantor allows grantee to bring not more than 20 visitors onto the property, not more than 5 times a year at mutually convenient times for research and education and recreation and so forth. And it's a nice opportunity for the holder of the restriction to have. And it's way short of public access, but it does open up private property a little bit.
Indeed. So we only have 8 minutes left before we'll cut this off. But I've waited to this point to tell you that after yesterday's, in the networking sessions yesterday, all the networking sessions got filled up, and I was incredibly frustrated by the prospect of this meeting not being able to see and hear the participants. So I did a lot of work last night, and the Rupert and Rob and Barbara did a great job. So the networking sessions that occur right after this are, first of all, up to 40 people instead of 16 people. Only 16. The first 16 get their pictures, and the other 24 are voice only. But I also got a legal forum networking session set up. So the first 16 of you that run over and sign up for the legal forum series will have pictures. I hope the four of us will have pictures, and I hope as many of you who would like to make verbal to be seen and heard, we'll do so, and we'll go by raised hands. Then you don't have to write it down. Thank you for all the Q&As that we did have in. We've been focusing a lot on easements. So we're not quite done yet, Steve, but we're focusing a lot on easements here. And my friend, my new BFF Kelly. Oh, yeah, you should all. Yeah, all you have to do is go back to where you hook into the main thing, and instead of saying main room, there's a place that says networking, and if you click on networking, it will tell you what's available. And if you click on it and there's room, they'll let you in, and if there's not room, they'll tell you there's not room. So let me go back to what may end up being the last one, except for some comments from the other three of you. The question is, Kelly's question is that if the easement says, if the trail easement says, either whether it's in a conservation easement or not, trail easement says we grant the right of access across private land to the land trust. How wide does that occur? Does that extend? Does that extend just to the board staff, or just to the board members, or just to the community, or just to the region in which the land trust is involved, or to the world at large? And I would say that all has to do with the intent of the grantor. It wasn't terribly well written when you say that, but if the land trust has 60 miles of trails that are open to everybody, and they receive a trail easement to the land trust, I think that a court would interpret it, and therefore we would operate it as if it's open to the public, even though it doesn't state to the public. Does anybody disagree with that?
No, I think you have to, if you were, you're transferring the property to an entity which has as its mission all these activities. So unless you said you can't do anything and it's limited, would have to limit it specifically to the board and the officers of the, of the association. But if your general transfer to the land trust, I think Chuck would agree with that, is that, it's for all the purposes for which the land trust operates.
Right.
Yep, I agree.
I think that's true. Okay, so that is good. Let's run a few. Can you get final statements? I'll go in reverse order. Sort of any comments here, and then we might have still a minute or two left over. But I got to write a note to Mike. Steve, why don't we go Steve, Kathleen, and Chuck for sort of a wrap up thoughts here.
Short point, and that is some of us, not all, been aware of the Biden administration's announcement of 30% of the land of the United States protected by 2030. That number 30 is a useful number because for the past 30 years, and some of you have heard me say this before, private land conservation or land conservation in this country has been supported by conservation easements and federal funding. And we're not going to get to another 450 million acres of land with conservation easements and federal funding. And the point that I've been making for some time and want to make again today is people need to start thinking about what I call a bigger toolbox. What other tools can we bring to bear? And I think in many cases, these are going to end up like capitalism, like carbon credits, like water credits, like green credits, like habitat credits, to bring millions and millions of dollars of private money into protecting a resource and making a fair, modest profit, socially responsible investing. Socially responsible investing has sort of been in one direction, at least the thinking, but I'm talking about all kinds of new ideas that can save land and attract people for capitalist reasons. It's got to happen.
Great. Thank you. Before we move on, Mike, I can't get into the breakout session. Would you please, we'll have to go lobby. Would you please make sure that Chuck and Steve and Kathleen can get into the networking session? They should get priority for that. Thank you. Kathleen, thoughts?
I just wanted to point out that, CPA money can be used for all kinds of things, and open space has a broader term these days. Then CPA money is actually being used for, food, farming efforts in cities and town, especially cities. And so I think we have to take a broader view of what, what open space means, and to make sure that we're creating spaces in places where people need them. And hopefully with the new housing choice, we'd be working with affordable housing projects and other kinds of things in natural resources, residential developments, to make sure that we're providing open space where it's most desperately needed.
Super. Chuck?
Yeah, I would just say that one of the things over the last year that we've seen is the market on Aquidneck Island is through the roof, as I'm sure it is in a lot of your communities. But I really would echo what Stephen has said about having a larger toolbox. And one of the things that we're looking at is, yes, we need to be conserving land, but we also need to change our land use patterns so that we're looking at more innovative zoning and mixed uses as a way to take the pressure off of the open space lands.
That's perfect, and it leads to mine, which really does also sneak back to land uses. Your last sentence is I think directly on point, Chuck, and some of the statutes, including the Housing Choice Bill and another bill that just came out of the Massachusetts legislature, work to that end. Unfortunately, the climate change bill hasn't picked up on that zoning matter very much at all, even though we are about to have the most innovative climate bill in the country. But I think we need to continue this. I think we should continue this conversation in about 15 minutes in the chat room, because like Steve, who went large about needing a new toolbox, and Chuck alluding to the same, I think that is the crucial aspect for the future of conservation. And it may not be a legal issue, so we can still talk about legal issues. But I think we're right at the watershed of whether it's called carbon pricing or not. I think we are right at the watershed where we understand that saving forests and saving farmlands and saving estuaries are really crucial to our dealing with the climate problem. And we're not going to sequester carbon in all those places unless we find a way to reasonably compensate the landowners for at least any additional work they're doing, and we save the land. So on that note, we're 1 minute over. I hope everybody gets what Rob Johnson likes to call a bio break.